Hey guys, Tom for another weekly legal tip. Today is seller remorse, and we are seeing lots more of seller remorse right now. I think I had 3 phone calls this week alone where the seller did not want to sell the house even after contract. And one of the cases was the day of closing. And so I think the reason we're seeing more and more of that is because the sellers are not expecting you to sell their house in 24 hours and have 17 offers. So I don't think that they truly have thought through the process of the now what. So they've got the house on the market, somebody wants to buy it. Now what are they going to do? Well, there's nowhere for them to go because they look for a house and they hadn't found a house. And so they panic and go, well, there's only 1,000 houses on the market in Columbia right now. So the normal 4,000. I'm afraid I'm not going to find a house, so they want to back out. And we've had that happen several times where the person's either their house they were trying to buy fell through, or they just couldn't find something they liked. And so they decided to back out. So let's talk about legalities and realities. That's what I always like to talk about. Legalities are the seller's in default. No ifs, ands, or buts about it. Whether you're using the CCRA contract or you're using the state contract, the seller's in default. They're under contract to sell the house, to sell the property. There's no out for the seller because they changed their mind. Nowhere in these contracts does it give the sellers just, you know what, if you change your mind, you can back out of it. By signing the contract, they have already signed saying they've agreed to sell the house. So one of the things you could do as a listing agent is to have these conversations with your client to make sure they fully understand that once they sign this, it's over. They can't back out of it for any reason whatsoever. It's contract, and they're obligated to fulfill it. And so if you're looking under the CCRA contract, the default provision is in paragraph 21, and under the state contract, it's paragraph 23. And though the language is different, they essentially say the same thing. The buyer can terminate the contract and receive earnest money back is one option they can do and just move on. The other option is they can sue the seller for any remedy under law. It's the language they use in both contracts. And remedy under law would be any damages, but it also would include specific performances. In fact, the CCRA contract, when they talk about damages, they actually talk about actual costs incurred by the buyer, which would include things such as a credit report, appraisals, survey, inspections, reports, title examinations, attorney fee, even real estate brokerage fees. So the seller has a tremendous amount of liability financially. You may have other damages too. If a seller has or a buyer has already sold their house and now they don't have somewhere to live and they have to go rent a house or live in an apartment, there could be some expenses there. If their interest rate that they were going to close with you was at 3% and now 6 months later, when you finally decide that you're going to sell it to them, the rate's 3.5%. There could be that rate buy down. So it's thousands of dollars there. And of course, the court could do what's called specific performance, which is to make the seller sell the property. So that's the legality of it. It's not a good position to be in with the seller. On the realities of it is, I'm starting to see more and more buyers take this route. And what they will do is they'll file what's called a lis pendens, which is basically it's a document that's filed against the property that prevents the seller from selling it to anybody else. And it says, I'm going to file a lawsuit based on this property. So if that happens, the seller's not selling it to anybody else, and they can go to court. And it's kind of 50-50 as to what buyers do. A lot of times the buyers just say, I don't want to be involved in it. I don't care. Just give me my money. I'll move on. But occasionally in a tight market like today, you'll start seeing buyers push back and say, no, you're going to sell the property to me or I'm going to sue you. And the cost can be very, very expensive. So what I have seen sellers have to start do now, talking about realities, when they don't want to get sued, they don't want to sell the house, they're having to pay the buyer not to buy their house. I've seen one situation where they've literally offered $5,000 for the buyers just to go away so they can keep their house. So understand, if your seller is going to back out, there's tremendous liability. All right. Hope y'all enjoyed this week's legal tip. Next week, we'll be back. I'll be off for the next 2 weeks because of Christmas and New Year's. There won't be a legal tip both next week or the week after. But coming back the first of the year, we'll start back with legal tips. Take a chance if you have some time this week to listen to our podcast this week. We had a really good podcast on tax sales and the personal professional liability you're committing most of the times when you're handling those because the contracts aren't being done correctly. And you can also check out the library of other ones we have, such as escalation clauses, wholesaling, and things of that nature. A lot of good podcasts in there that you can listen to over the Christmas break. Hope everybody has a Merry Christmas, and we'll see y'all in the new year.